Hello, and thank you for joining us for today's webinar. My name is Janice Ziegler. I'm a partner in the Denton's healthcare practice. I'll be joined in this initial presentation on charting the future of AI in healthcare by my partners Rami Fayed and Peter Stockberger. Rami is also a partner in the healthcare group, and Peter is in our AI and emerging technology practice. Before we get started, I have a few housekeeping matters. For the benefit of all participants, attendee lines have been muted. Should you have any questions that you'd like to submit during the event, you may submit them through the question and answer space. If we cannot address your questions today during today's webinar, we'll follow up after the program. Please note that today's webinar will be recorded and circulated to all registrants via email after the event. Should you have the follow-up questions at that time, please reach out to any of the key contacts listed in the email communication. Note, Denton's can only issue CLE credit for attendance during the live broadcast of the webinar. Participation on the live webinar must be on a computer or laptop device. Credit is not available for joining via a mobile device. One other important note, if you have a New York, New Jersey, Pennsylvania, or Kansas license, please be sure to listen to the code word during the program. When prompted, you will need to enter the code word into the Q&A session on the screen. If you don't have a license in these states, you can disregard this instruction. Next slide. AI is obviously a hot topic of the day. It's hard to go through a day without hearing numerous times about the promises and perils of AI. The purpose of today's presentation is to provide you with a solid understanding of where the technology and legal landscape stands in the healthcare space and how to mitigate potential risk through smart AI governance. Our presentation will have 4 parts. First, we'll discuss the current status of AI innovation and future trends. Then we'll discuss where AI adoption stands in the healthcare context today with specific examples. Next, we'll dive into the murky AI legal landscape. And finally, we'll focus on practical considerations aimed at risk mitigation during this evolutionary period. With that, I turn it over to Peter.
Great. Thanks so much, Janice. And thanks everybody for joining us for what we hope to be a illuminating conversation about the state of AI in healthcare. As Janice noted, in this first part of the discussion, we wanted to highlight some of the trends that we're seeing in how the technology itself is developing, which I think gives important context for how it's actually being deployed within healthcare institutions, as well as the vendors that are supporting the healthcare ecosystem. And it wouldn't be a good webinar on AI without a basic definition of what is AI. And I think it's important to keep in context that artificial intelligence as a general category is a very broad category of technology. The definition that I like to use actually comes from the California state legislature. This is a new law that California passed effective January 1 of this year that says all definitions of artificial intelligence under state law need to take this definition. And this definition, I think, is helpful because it also tracks what the federal government has adopted in federal legislation. We see this definition similar to what's been adopted internationally. And it's a very broad definition. So it's any machine-based or engineered system that varies in autonomy, which is an important component, that can basically infer from input and generate output that can influence a physical or digital environment. A lot of people think this definition covers all of software. So it's a very broad definition. And I think for context, it's important to understand within that AI ecosystem, that large umbrella, there's really 2 categories of AI that has developed over the years. Historically, for decades, AI has been deterministic or rules-based. This is what drives our basic computer function or our email spam filter, where it says, if an email contains this word, put it into your spam filter. That's a rules-based system that is saying, I know what the outcome is going to be based on the presence of this factor. And that's historic computing. But where we see most of the innovation and development over the past 10 years has been in this area of predictive AI. And within that category of prediction or probability AI, we have the large category of machine learning. Machine learning is essentially taking an algorithm and teaching it on a historic piece of data. So whether that's a small data set or it's a very large data set, you're teaching the algorithm about this historic data set, and it's learning how to make different adjustments and predictions based on that data set. That's baseline machine learning. Within that broad category of machine learning, we have another sector called deep learning. And deep learning is essentially taking multiple levels of machine learning and connecting them together like a neural network, like a brain, where it's firing off different weights, giving different weights to different factors, and it's more complicated reasoning. That's sort of deep learning. It's within that deep learning category that we saw the launch of generative AI, which was displayed to the public in November of 2022 when ChatGPT was released to the public by OpenAI, even though this concept of generative AI came a few years before. This is a form of deep learning that's based on what's known as a transformer architecture. Not to get too in the weeds on the technology, but essentially it's a deep learning architecture that for natural language input, so you're typing into it, write me a poem for my 6-year-old son, it is going to its historic data and pulling out what's the probable next word in a sentence, or the probable next pixel in a picture, or the probable next frame in a video. So it's a probabilistic tool that is based on a historic data set. And that's important to understand because generative AI has been the dominant form of AI that's been in the headlines that organizations have been talking about, including in the healthcare space. But there's a big perception right now that generative AI as a category of AI is sort of on the downswing in terms of its effectiveness. And I think this slide is helpful. This is a chart that Gartner issued last year called the hype cycle for artificial intelligence. And this basically shows that there's a lot of different innovations in AI happening, from quantum to embodied AI, which is robotics. And generative AI is just one part of that larger picture. And so we're really, I think of it as we're in the flip phone stage of the smartphone evolution. And generative AI is just the beginning, which is, I think, an important concept for everybody to keep as they look at their enterprise development. So Gartner believes that generative AI is on this, it's already reached what they call a peak of inflated expectations, and it's moving into a trough of disillusionment, which means it's running into a scaling problem at enterprises. And the reason why it's running into a scaling problem is because the models themselves are dependent on the historic data upon which they're trained, and they can sometimes make mistakes. So there's a reliability and an accuracy problem. But I think if we're looking at trends in the technology, generative AI continues to be dominant. We continue to see accelerated developments in the generative AI industry, both at the model layer, and these are the companies like OpenAI or Microsoft or Anthropic that are building the actual models. We see an explosion of development at the infrastructure level. These are building out data centers, chip manufacturing, hardware and software to support the processing. We see an explosion at the application level, vendors actually building generative AI solutions for enterprises. So that continues to be a dominant force. We are also seeing something called agentic AI on the rise. And agentic AI, in its basic form, is an AI system that can plan, reason, and carry out tasks autonomously, sometimes with little to no human oversight. And a lot of commercial providers like Microsoft and Salesforce are releasing what are known as agentic systems, which we'll talk about a little bit later. And then the final trend that I wanted to make sure was on everyone's radar that's going to impact the healthcare industry significantly is what folks are calling physical AI or embodied AI. This is taking the digital AI solutions, the software that we're all familiar with, and embodying them into physical manifestations like robotic arms, robots, humanoids, autonomous vehicles. And major AI companies right now are working aggressively to build physical AI for the next generation. And I'll leave you with this, at NVIDIA's GTC conference, their big sort of confab for NVIDIA, sort of like when Apple would release the new iPhone at that type of conference, the CEO of NVIDIA highlighted that physical AI is the next gold marker in the AI industry. So I think that's really going to impact the healthcare industry, Rami and Janice, because obviously robotics in the operating room, robotics in the clinical care setting are going to be something to watch. So that just gives you a snapshot of where the technology is heading. Rami, I wanted to toss it over to you because we're going to look at, as that technology is emerging, how are companies actually adopting the tools? And Rami, I think you were going to start us off looking at this interesting 2025 NVIDIA survey, speaking of NVIDIA, that came out earlier this year.
Yeah. Thanks, Peter, and hello, everyone. Yes, so everything that we've been talking about or what we're seeing is that there's the opportunity here for AI applications to be not only additive to what we're doing and what we're seeing, but has the ability to disrupt and transform the practice of medicine and the delivery of healthcare. And a couple of surveys over the last 12 months kind of show us where that uptake is, or what people's attitudes are on it. Not on the slide. Before we get to the NVIDIA one, there from last year, McKinsey, just for contrast and comparison, 70% of healthcare organizations are pursuing or implementing some type of AI capability with opportunities to kind of assess where they are, what the risks are, governance, and other maturity factors in terms of how they are being implemented across their organizations. And from the folks who have implemented it, the study shows that nearly 60% are reporting a positive ROI, or at least expect to in the near future see that return. Now, that was in 2024. The NVIDIA survey from this year shows a pretty similar set of trends and responses, where nearly 2/3 of respondents are actively using AI, so similar to what we saw last year. Similar percentage also believe that their company's investment in AI is currently not enough, which kind of is, that there's this insatiable appetite for more and more growth in the space. And so even though a good chunk are using it, people want to see more and more of it, and in all of its newer variations that we'll talk about as we go through the presentation. So overall, I think what we're seeing is that the responses show at the same time a level of excitement around the adoption of it, but also a level of frustration that their companies haven't invested enough in AI, and that we will continue to see that as things continue to mature and grow over the balance of this year and into the future. And with more surveys, Janice, I think you were going to talk about the AMA.
Yeah, so physicians will obviously play a major role in terms of AI adoption in the healthcare space. And for several years now, the American Medical Association has been conducting an annual survey of physician views regarding the use of AI. What we see in this year's survey is that while physicians see the potential promise of AI, they remain wary. So the report shows that the proportion of physicians whose enthusiasm exceed their concern with regard to healthcare AI increased to 35% in 2024, up from 30%. So clearly, physicians do have lingering concerns about the use of AI. That said, the majority of physicians see at least some advantage to using AI tools, and the percentage is increasing up to 68% this year. Most notably, 66% of physicians surveyed indicated that they used AI in their practice, up significantly from 38% in 2023. So this shows just the acceleration in AI adoption as more and more healthcare organizations bring AI within the fold. We see how physician views regarding AI are evolving as well. In 2023, the top concerns among physicians with respect to use of AI were data privacy assurances, not being held liable for AI model errors, and medical liability coverage. But in 2024, the focus is a little different. Physicians surveyed were more concerned with practical issues, including the need for designated feedback channels and EHR integration. Notably, the surveyed physicians resoundingly expressed the view that additional regulatory oversight is needed to increase physician confidence and adoption of AI. So I think physicians are feeling a little bit of the vacuum that exists right now as well.
Yeah, I think that's a perfect segue into looking at those two surveys about how AI is actually being deployed in healthcare settings. And we really see three trends. One is what we're calling general use applications. So these are things like Copilot on your laptop or ChatGPT on your phone, general tools people are using for general work purposes. The second trend we're seeing, and Rami and Janice are going to dive into some concrete examples, is around decision intelligence, using AI to drive better decisions, both on the operational side, let's say in HR, finance, or accounting, and also on the clinical care side in delivering healthcare. And the third trend we're seeing is really using agentic AI to replace workflow, to automate certain workflows. So in these three buckets, the first category is one that we hear people talk about a lot. This is a challenge facing all organizations, including those in healthcare. And that is folks using AI applications generally in their day-to-day work. I think Rami and Janice, you both highlighted in your survey, folks are nervous about some of these tools from a privacy perspective, from an error perspective. And that's where these general use tools can present some risk. A survey from Microsoft and LinkedIn last year across multiple countries and thousands of workers showed that 75% of workers are using AI, and that's across generations, and most are not reporting it to their IT teams. So they're calling it a shadow AI or BYO AI. I think the challenge here is, how do you control that within an organization? How do you ensure that people are using it for the right purposes? And I think the best guardrails here that we're seeing emerging with companies is a good acceptable use policy, strong training and culture, and education about what are permissible and non-permissible uses. And within the healthcare space, we're starting to see more organizations develop their own in-house proprietary tool that can function like ChatGPT, but you're encouraging people to be in your secure environment, maybe perhaps your HIPAA compliant environment, rather than going out and using tools on the open market. So this is a challenge that is always sort of there, lingering in the background. But Janice, I think the more interesting part of using AI in healthcare is using it in this sort of decision intelligence, driving more efficiencies, not that general use, but really targeted uses, which I know you and Rami have been tracking and are seeing. It really varies across organizations in terms of the use cases.
Yeah, and I think that Rami's going to talk a lot about kind of the clinical applications. I think what I'm going to address first is just some of the improved efficiency in the delivery of healthcare. What we're seeing is significant potential through various products that are being offered, and the range of uses we're seeing is both remarkable and potentially transformative, interesting both for the clinician but also for the patient experience. A growing number of healthcare organizations are turning to AI to address administrative burden and combat physician and clinician burnout, which is real and troublesome. I think that a lot of these tools have the opportunity to manage costs and to really improve efficiency. For instance, healthcare organizations are increasingly using ambient listening technology to capture provider-patient conversations and then generate visit summaries. Many doctors report that these summaries, which they then review and approve, save significant time and provide more consistency and greater detail than they might have included on their own or with the use of a medical scribe. Similar technologies being used to generate template forms for referrals and prior authorizations, which are the bane of every physician's existence. These benefits, however, are not without their downside. For example, just as cloned physician notes raise concerns in claims review, the same might be said of AI notes that look similar or are not adequately reviewed or customized. So the tools need to be used deliberately. As we'll discuss more fully later, many insurers are using AI to assist in preliminarily reviewing prior authorization and claims approval requests. But what's interesting is we now see AI chatbots being used by providers that can synthesize data from medical records and then draft prior authorization requests and appeal letters to insurers, saving time and increasing the likelihood of success. AI is also being used to assist maximizing available healthcare resources, to streamline clinical workflows, and to handle scheduling and other tasks so that the personnel within the office can use their time to attend to other, more direct patient needs. For instance, we're seeing GPS-enabled health apps streamline patient check-in and triage by verifying insurance and pulling patient charts. The examples are really endless in terms of what's being done to make the ecosystem more efficient through the use of AI.
And building on what Janice and Peter have been talking about here in this area of decision intelligence is we're really starting to see how we can harness the power of AI and this targeted use to help us better decision making across operations and clinical care delivery. And Janice gave a few examples of that here, but there are others as well where we're starting to see AI decision intelligence in stroke detection with tools like Rapid AI or Viz AI, where they're using image-based AI to analyze a patient's CT scan. It can alert the care team of potential stroke within minutes. There are still humans involved in this process, as with most of these decision intelligence tools, where they are still reviewing those CT scans, but the technology helps those clinicians prioritize the cases where there is a higher likelihood of a stroke, and especially in a field like stroke, where every second matters in the detection process. This has the ability to speed up our decision making and drive care more accurately and quicker for patients. That same type of technology is also being used in cancer detection. There's a model out of Harvard called the Clinical Histopathology Imaging Evaluation Foundation. If I said all the words, it should end up as chief. And it's showing great promise with, at present, about a 94% accuracy in cancer detection. And it also has capability, although still in the testing phase, to predict patient survival as well as a tumor's molecular profile. So certainly, as it continues to grow in these spaces, and as we see its use in more traditional kind of clinical decision support systems, where you're kind of building on machine learning algorithms, neural networks, decision trees, and natural language processing, you're able to now make quick and accurate decisions. You can use them in the ER to triage patients by priority, develop treatment plans for complex conditions. And as we continue to grow these uses, next slide for me, Peter, we're also seeing that rapid deployment of this in the drug development space, where we're getting to the point where we're able to design better clinical trials, as well as conduct more targeted post-market safety monitoring. Huge possibilities as we look to find ways to bring new medicines to market in a faster and more accelerated and more accurate process for patients to be able to take advantage of emerging therapies. There are also other solutions that have been around now for a few years, like the IDX-DR software, which was cleared by the FDA back in 2018, which is capable of autonomously diagnosing patients with conditions like diabetic retinopathy. And I think that we'll continue to see more and more opportunities for helping in the diagnosis of disease states across the spectrum, not ones that are just more, attuned to image-based studying and, abilities to identify those diseases that way. But away from the treatment side of things, we're also seeing it in use by the government in its ability to audit for potential fraud and abuse. Now, this is obviously something that CMS has been doing for quite some time in terms of accessing large data sets and looking for anomalies in claim submissions to identify potential behavior or claim submissions that do not kind of fall within the normal standard of deviation. But that next step that we're seeing is to use these technologies in a way that doesn't rely on past or known fraud schemes, which is allowing them to kind of anticipate better new fraud and abuse patterns as they are happening in real time. Now, of course, that technology is going to have its pitfalls. It's not always going to be accurate. There may be very good reasons why a particular provider is an outlier and why they're not. And you're going to find yourself still having to respond to audits when maybe what you're doing is perfectly fine. So there's an increased cost for providers on that side. But as the technology continues to improve and fine tune, the hope is that it will be able to filter out those irregular or sort of false positives, if you will, as we move forward. And then
Yeah, and I think
Peter, a little better.
those categories of decision intelligence are really important. That's where the bulk of the value is right now inside of healthcare organizations in terms of getting ROI on AI. An emerging area that's still very nascent is using agentic AI to automate certain workflows. So agentic AI, again, is AI that can reason, plan, and take action by accessing tools without human oversight. So these are AIs that can act autonomously within systems. Gartner thinks that by 2028, 33% of enterprise software is going to be agentic. And we're starting to see a real push in the industry from Salesforce through Agentforce. Google's building agentic systems. I think the impact on healthcare is going to be, there are a lot of workflows, Janice, you noted, reducing burnout, reducing a lot of that monotonous task work. It could be solved by agentic AI. For example, I've seen some tools on the market that will call an insurance company for a doctor getting pre-authorization for a procedure and engage on the phone through a voice model with the insurance company. The doctor never has to speak to the insurance company. So you can see the attractiveness of agentic AI. The challenge, the risk with agentic AI is it's not that reliable in the current environment. And Rami, I think it wouldn't be a good AI webinar without talking about the risks. We've been talking a lot about the benefits, but obviously these tools have a lot of risks, which will lead us into talking about what the state of the law is. But I know you and Janice have been seeing this firsthand, where these risks sit in deployment.
Exactly. It's, as the saying goes, with great power comes great responsibility. And here, as we rush to continue to use these AI tools, there are these challenges that we're finding in the deployment process, where, especially in an industry that is as risk averse as healthcare, where the room for error is not as great as it may be in other spaces. Having Copilot not get the tone just right in an email you ask it to draft is a lot different than missing a diagnosis or incorrectly treating someone or something of that nature. So the responsibility here in terms of accuracy and reliability with these tools is something that we're seeing a lot of our healthcare clients spend a lot of times as part of their responsible use initiatives, really testing and validating, understanding what went into these tools and making them, their accuracy rate, and how they can continue to improve them, which also then brings in the question about how do you protect protected health information and other personal information that healthcare providers are using. And there's a lot of debate about the best way to protect and secure PHI in these AI models. We're seeing, there are a couple different trends that are evolving here, to help minimize the risks with these large merged data set and the loss of control that might be necessary to meet requirements under HIPAA and what have you. We're seeing some companies that already have access to their own large data sets, maybe they're a large system or what have you. They tend to develop tools, that are just built off of their data alone, so that they can have better control over what is going in and what is going out and what controls they have. Of course, that's not going to work for providers that may be of a smaller side. And so for the smaller providers, we're seeing them now start to gather into groups or pods of providers to help leverage that same type of large data set through smaller providers. And they're doing it, with either forming some type of clinically integrated network or organized healthcare arrangement or what have you, that allows them to achieve the same opportunities that you can get through the, large provider that has access to a much bigger data set. All of these still obviously have a lot of challenges, regardless of how the data set is built, in that you still are facing issues around IP infringement, which continues to be a hotly litigated area in these AI models that are synthesizing large data set. Does copyright, patent, trademark infringement apply to AI creations? We see lawsuits on alleging that the generative AI models used original works without license. And so the bounds of the derivative work will be resolved over time in the courts, but it leaves companies open to potential litigation until these issues are resolved one way or another. Janice?
Thanks, Rami. So, Rami touched on kind of the human safety issue. I think that's perhaps one of the biggest concerns with AI, that you're going to have a misdiagnosis, a hallucination, or some other error that results in harm. For this reason, the FDA focuses on the total product life cycle in AI-assisted devices and encourages continuous monitoring and testing to ensure against data drift and other unintended consequences. We're also seeing a real emphasis on compliance-related, elements being applied to AI, and trying to make the use of AI as appropriate as possible. The use of AI raises many new questions in the liability context. Who's responsible if something goes wrong? Is it the clinician or the developer? How can and should liability be allocated between the developer and the deployer? We're seeing lots of fierce negotiations with regard to arrangements between the two. How will the use of AI impact insurance coverage selection, pricing, and availability? What kind of consents are necessary when you're using AI? Interesting whether the use of AI will eventually become the standard of care, such that the failure to use AI would itself be considered a deficiency. So as Rami was pointing out, the courts are grappling with many of these issues right now. And so this is a period of evolution and a lot of grayness. With regard to fraud and abuse considerations, we're increasingly seeing providers using AI to assist in developing medical records, as well as with respect to coding and claim submissions. And so a big question is, what are the implications from a False Claims Act perspective if the output is not supported and is submitted to the government? What kind of controls need to be implemented to combat and detect errors, and to demonstrate good faith use of these tools, particularly where healthcare reimbursement is at issue and can result in significant potential exposure? And as we'll see in a few minutes, the Department of Justice has already provided some thoughts on these issues in a guidance document with regard to the questions that organizations should be asking about their application of AI. So we'll unpack that a little bit in a bit. In all of these areas, use of AI, wherever AI is being used, bias and discrimination are big potential concerns. And as Rami said, there's all these tensions in terms of, using the data and wanting to make sure that it's your data. But then again, if you're only using your data, does that create a bias? Is the training set too limited in one shape or form, such that it might result in biased results leading to discrimination or other unintended impacts? So these are all challenges that organizations are facing as they consider the use of AI.
Yeah, and I think one last challenge note before we turn into the legal landscape is around agentic AI. Agentic AI, to your point, Janice, introduces new concepts of liability. Who's responsible when the AI does something on its own and is acting autonomously? So I think that issue of medical malpractice and responsibility becomes a challenge. And then Rami, to your point about security being an underlying challenge, well, these agents access tools by themselves through API connections. So you can imagine all of the different security issues with an autonomous software accessing other software and all the injection points for bad actors. And finally, one thing that you mentioned earlier, Rami, is accuracy and reliability. How do you know if what the agentic AI system is doing is reliable? And I just wanted to highlight this from Gartner. Again, they said, beware of the AI agency gap. AI agents are impressive. They're showing increased autonomy, but they are not as good as humans. They don't have the level of agency that we do, which is they can't make their own decision. They don't understand the physical world, which is ultimately a current limitation in the current state of the art. So that's our sort of landscape of how AI is being deployed in healthcare organizations. We now want to shift gears, because we're all lawyers, talk about the underlying legal landscape and how that risk is manifesting in the law. But before I do, I just wanted to highlight the CLE code word. As mentioned at the beginning of the webinar, Janice, we need to take a brief moment to satisfy our CLE requirements. For all Kansas, New York, New Jersey, and Pennsylvania licensed attendees, you have to type the code word, which is global, into the Q&A section of the screen. Make sure you hit the send button so it registers. And in case you missed it the first time, the word is global, and that's for Kansas, New York, New Jersey, and Pennsylvania. We'll give folks a moment to type that in before we dive into the always clear legal landscape around AI in the US and globally. All right, so shifting gears into the legal landscape, first just wanted to give you a sense of what's happening at the global level, because I think it's informative into what's happening at the domestic level. And I'll say at the global level, we do have a forming consensus amongst countries that there is a need to regulate AI. What is not consistent, however, is the proper way forward. And the snapshot, the picture on the right, is from the Paris AI Action Summit that recently occurred, where Vice President J.D. Vance came and said, we disagree with most of you about how to regulate AI. We think AI innovation should be at the forefront rather than AI regulation. And what we see emerging globally are three sort of buckets of laws being developed. One bucket is what we're calling risk-based approach. So this is what the EU AI Act is, the South Korea Basic AI Act, in the US, the Colorado AI Act. These are laws that regulate high-risk use cases of AI. And under all of these legal regimes, deploying AI in healthcare is considered high risk. So that's a risk-based regime. We then have another bucket of countries that are more promoting innovation. They're promoting industry self-regulation and research and development funding. And that's Japan. We see that in Singapore, in the UK. That looks like it's what's going to be the approach at a US federal level. And then we have the third bucket, which is unique to China, which is central management of all deployment of AI within the country. And China really sort of stands alone in that category. So at the federal level in the US, with that global picture in mind, we really see a murky picture emerging at the federal level. President Joe Biden had issued an AI executive order in October of 2023, setting the standard, expectations, and rules for federal agencies and their deployment of AI. President Trump, not surprisingly, fully rescinded that executive order and issued one of his own, announcing that innovation is the call of the day. Innovation and winning the AI race with China. So he's appointed a new AI czar, David Sachs, who's from PayPal. And they recently had a public call for comment on developing a national AI strategy, received thousands of comments as of March 15th, some of which have been made public. But innovation is really the call theme from the federal government. Now, there are some additional rules coming out at the executive level. We have an export control rule that still is in effect that regulates export of certain hardware and model weights. We see some of the executive agencies start to comment about their approach to AI, including the FTC and the EEOC. We do not have federal legislation yet, and whether this particular Congress will push forward bipartisan AI legislation, I think, remains to be seen. I'm personally not holding my breath for any federal solution at the legislative level. But I think what's more interesting, Janice, is something that I know you've been tracking heavily, is the developments at the HHS, FDA, the other federal healthcare agencies. They seem to be really at the tip of the spear in this healthcare space.
Yeah, I think taking the lead from Biden's executive order, there are many components within the Department of Health and Human Services that have been active in AI oversight, guidance, and regulation, including the Office of the National Coordinator for Health Information Technology, the FDA, the Office of Civil Rights, and CMS. And so we're going to walk through a little bit, through what those agencies have done and where things stand. It's unclear what role these agencies will play under the Trump administration, especially since much of the work that was done previously was focused on health equity and non-discrimination, which were two hallmarks and pushes of the Biden administration in the healthcare area. So Section 1557 of the Affordable Care Act prohibits discrimination on the basis of race, color, national origin, sex, age, or disability in healthcare programs or activities that receive federal financial assistance. And the Office of Civil Rights promulgated a final rule implementing Section 1557 that's scheduled to go into effect on May 1st, 2025. The rule applies to entities, including hospitals and physicians that receive funding from HHS, as well as programs and activities that are administered by HHS, including the Medicare Advantage programs and Medicaid managed care. It also applies to insurers that participate in the health insurance exchange. And so the final rule required these entities to make reasonable efforts to identify patient care decision support tools that they're using that employ input variables or factors that measure these various factors that we identified, and then mitigate the risk of discrimination resulting from such tools. The rule describes patient care decision support tools very broadly. So it includes autonomous tools, as well as those that assist or augment the responsible entity's decision-making. Whether the rule will remain as is under the Trump administration remains to be seen. Whether it will be challenged under the new standard for administrative review of rulemaking established by the Supreme Court last year in Loper Bright also remains to be seen. I think the key takeaway, though, is that the underlying statutory obligations will remain. And therefore, even if we don't have the specificity that we see in a particular rule, covered entities will be responsible for mitigating discriminatory risk in the deployment of AI. Next slide. With regard to the FDA, certain AI software is regulated by the FDA as AI-enabled software as a medical device, depending upon how the software operates and what claims are being made. As of December 2024, the FDA authorized a little over 1,000 AI-enabled medical devices for marketing in the United States. In 2015, the agency approved only 6 of these devices, while in 2023, they approved 221 devices. So we see there's a very quick pace of product development in this area. Looking at the FDA in general, a key regulatory challenge is overseeing a product that's not static, but rather changes over time, and specifically how to predict, control, and mitigate that change over time while preserving safety and effectiveness of the device. So the FDA is acutely aware of the uniqueness of AI as a product, and they've tailored various papers and guidance documents to try to aid the industry, and particularly the product developers, in understanding, monitoring, and refining their approach to AI. In January 2025, the FDA issued draft recommendations regarding the content of marketing submissions for devices that include AI-enabled software, with a focus on risk management throughout the device's total product life cycle. The future of this guidance is unclear. The Biden administration, there had been under the Biden administration a schedule for a call to review the draft guidance, but that was canceled without explanation. It's unclear whether that's a real pullback from the guidance or just a natural pause of a new administration coming in. But in any event, the January recommendations and other FDA guidance documents and discussion papers and action plans remain helpful guideposts regarding the FDA's historic approach, and also contain sound practical advice for those implementing AI. I think those documents are really worth a good read, despite the fact that they're kind of on pause right now. With regard to CMS, they've been paying particular attention to the use of AI in coverage determination context for Medicare Advantage plans. In April 2023, CMS issued a final rule emphasizing that Medicare Advantage organizations have to ensure that medical necessity determinations are based on circumstances specific to the individual. The following year, CMS clarified guidance that while AI can be used to assist MA plans in making coverage determinations, there has to be individual review, and that the MA plan has an obligation to ensure that the algorithms and tools don't perpetuate bias. As we'll discuss in a little bit, the use of AI by insurers in connection with prior authorization decisions and claim denials has been the subject of several class action litigations. So in that case, the court dismissed most of the state law claims, saying that they were preempted. CMS has a new proposed rule that is out right now. And again, it's really designed to provide guardrails in terms of the use of AI in decision making in general. And I think the bottom line, it's unclear what's going to happen. CMS was voicing concern that the use of AI was resulting in algorithmic discrimination in the Medicare Advantage context. And so they were trying to sort of cabin that in. It's unclear what will happen under this new administration, but I think the recommendations that CMS made are very wise, that MA plans need to understand how the impact of recognize the limits and the impacts of bias, follow a process of regularly reviewing their systems, and then just deal with any known discrimination. So I think those practical recommendations are important. So the Office of National Coordinator had put out the HTI-1 rule. It creates a framework for sort of governing these technologies from a supply side by imposing obligations on developers. We'll see whether the Trump administration makes any changes to that, but portions of the rule are slated to be impacted in 2025. Okay, so these are the DOJ guidelines that I talked about before. In September 2024, the U.S. Department of Justice released an update to its evaluation of corporate compliance program guidelines. Prosecutors use these to evaluate compliance programs to see whether they're effective. And companies generally try to take a look at these as well in developing their own compliance programs. So the Department of Justice, added a section on AI to guide prosecutors in evaluating these programs. And they had a number of questions that I think are really important as organizations look at their own corporate compliance programs to see whether they need to tweak them in connection with AI. So how does the company assess the potential impact of AI on its ability to comply with criminal laws? What is the company's approach to governance regarding AI? Are there controls in place to monitor and ensure the trustworthiness, reliability, and use of AI and compliance with the company's corporate code of conduct? How does the company train its employees on the use of emerging technologies? And how is accountability over use of AI monitored and enforced? So basically calling out the 7 principles that we see in good compliance programs, but really tailoring them to AI. And these are the questions that the DOJ lawyers will be asking and that company lawyers should be asking as well, and updating and revisiting their compliance programs. With that, I'll turn it over to
Thanks,
Rami.
Janice. Well, the states continue to be the leaders on regulating AI. I think at last check, 45 states, Puerto Rico and DC, have introduced AI bills, and at least 31 have adopted either resolutions or enacted legislation. Obviously, this slide doesn't have that all of those on here, but just a few highlights or examples. Virginia, HB 2154 directs the Board of Health to amend its regulations to allow for the permissible access to and use of intelligent personal assistants. There's a California law that individuals be notified when messages are sent to them using generative AI. A law out of Georgia from 2023 would permits eye doctors to use a mechanism to conduct eye assessments and generate prescriptions. There's also a Massachusetts bill that requires mental health providers to seek approval from the licensing board before using such tools, and then if and when granted, then to disclose that AI is being used with patients and get their informed consent. There's also a slew of non-healthcare specific laws which apply equally to non-healthcare providers as well as they do to healthcare providers. So it's important that whether you're in the healthcare industry or not, to stay abreast of those developments, whether they're related to chatbots on websites or any type of consumer interaction and so forth.
Yeah, I think to that point, Rami, the trend in the state laws that are not healthcare specific, but touch on healthcare, are looking at things like notice, transparency, fairness, maintaining privacy. Janice, they track a lot of the federal developments that you're talking about at the HHS and FDA level as well. One of the areas that we see real state legislation right now on is in this high-risk system. So going back to that global slide, these are categories of laws that regulate high-risk uses of AI. California has a set of pending regulations under the CCPA that would restrict the use of automated decision-making technology, or ADMTs, in the healthcare setting. And there's lots of restrictions inside those regulations about notice, consent, doing risk assessments. Colorado has a law taking effect in February. This was a first of its kind law that was passed in the US that imposes robust requirements on deployers and developers of AI in the use of healthcare settings to do things like impact assessments, risk assessments, provide notice. So we're seeing a trend in these state laws. Now, I note Virginia here because we put the slides together before yesterday, and yesterday the Virginia governor vetoed the Virginia AI Act. So that law is not going to take effect, but we're starting to see this trend in sort of risk-based system laws at the state level. Data privacy is a topic that I don't think we need to spend much time on, but there are lots of states with data privacy laws that can really impact how data is used in AI systems, both feeding in and feeding out. A lot of complications there with the PHI overlay and HIPAA that Rami and I deal with on a daily basis. So you have to keep your eye on these healthcare specific data privacy laws and these automated decision-making technologies. Consumer protection is another area that we're seeing state law development. We have unfair business practice laws that are on the books. The attorneys generals of California and Oregon have been issuing advisories about warning companies, including specific to the healthcare space. Don't misuse AI, don't misrepresent how AI is functioning, don't overpromise its functionality. In the healthcare space, the California AG has specifically issued warnings about using it to overbook appointments, to mislead people in the clinical setting. California's had a law on the book since 2019 around chatbots, making sure you're disclosing to people that it's automated, that they're not engaging with a non-human. Utah has a law that took effect of May of last year. Same thing. If you're using generative AI to chat with a Utah resident, you have to tell them that they're interacting with generative AI. So this is all on that notice transparency trend. And we're also seeing a trend with eavesdropping, where the plaintiff's bar is alleging that eavesdropping, use of AI tools can constitute eavesdropping. Employment's another area for your HR department to keep an eye on. This could be a whole webinar in and of itself, but we have multiple states with laws restricting how you can use AI to review job applicants and make employment decision-making. Illinois, California, New York City, the Colorado AI Act, Maryland now has a law. So you've got to pay attention in your HR function to make sure use of AI is aligned with these state laws. And finally, aside from the federal law development and the state law development, we're seeing an emerging litigation battleground emerge at the state and the federal level. In the healthcare and insurance space, we're seeing increased litigation around claims denials and pricing. And our colleagues, Natalie Limber and Justine Margulis, will be diving into a lot of the insurance claim litigation that's going on in the next presentation. So we hope you'll stay tuned for that. We're seeing increased litigation and ongoing litigation around copyright infringement. So the allegation is that these big models are training their model on copywritten material. A lot of those cases are still pending in the federal court, so we don't quite know how that's going to shake out. We're starting to see lawsuits around agentic AI, arguing that the use of an agentic AI system is unfair, or electronic eavesdropping, or something similar. And we're seeing employment litigation grow. People alleging that the use of these AI tools to scan resumes or make employment decisions is discriminatory or biased, going back to that risk point, Janice, that you noted, which is discrimination sort of is a risk that overlays a lot of the tools being used, both on the operational side and in the healthcare delivery side. What's going to happen next in the litigation space? No one knows. I'm certainly not here to give the plaintiff's bar any ideas, but I think medical malpractice is an area that we may see as AI continues to be deployed in the clinical setting, and potentially areas of negligence and greenwashing, saying that you're using something that's environmentally safe. So a lot happening in the litigation space. I think the ultimate question then is, when we've got the use cases exploding, the ROI being delivered, we've got a murky legal environment, how do you put it all together and put together a governance program that tracks with the DOJ's requirements, Janice, but also emerging standards? And I think what we see at the state and federal level is folks want to see companies, no matter their size or their industry, deploy AI responsibly and in a trustworthy manner. Now, that always begs the question, because we're attorneys, what does responsible mean? What does trustworthy mean? And what we've seen is the development of certain frameworks be established that tell you what responsible deployment of AI means. And the principles on the right are really a principles-based framework. You want to make sure it's valid, it's reliable, it's safe, it's transparent, it's privacy enhanced. It's not a checklist, it's a principles-based framework to view deployment of AI. And this slide just gives you some sampling of those frameworks that are out there today and the principles that are aligned in those frameworks. So for example, the OECD at the international level has a responsibility framework. The NIST, National Institute for Standards and Technology, which is an arm of the Department of Commerce, has an AI risk management framework. So there's emerging frameworks, all tracking similar principles. And we see those frameworks and technical standards now starting to come out by ISO, by IEEE. So there's an emerging set of standards that you can benchmark a program to. And I think that's really important because we're starting to see industry standards develop, especially in the healthcare space. We've got Train, CHI, the Healthcare AI Challenge Collaborative. These are organizations of healthcare, both providers, suppliers, getting together, talking about what they see as a best practice from a responsibility standpoint. And so what are the key features of this? Well, Federation of State Medical Boards have issued guidance. We have those agencies issuing guidance. And I think all of this is pointing toward the importance of developing a governance program. And what are the pain points right now in the healthcare space? It's the pace of innovation. It's who's going to make the decision within the organization as to what's the right use case to deploy, and how do we know what the regulatory framework is going to look like. So our key takeaways here, and these are available in the slides for you to digest. Figure out what your AI strategy is. Who's going to make the decisions within the organization? Who's making the call as to whether a use case is a good, a bad, or an ugly? And where do you sort of bifurcate that decision making? Are folks at the operational level going to be making strategic decisions? Are strategic people going to be making operational decisions? That's a core component right now of building an effective, responsible AI governance program. The second component that I think you should walk away with is benchmark your approach. We see NIST, we see ISO, we see those AI-specific or healthcare-specific organizations developing benchmarks. Think about how you're going to benchmark your program. Leverage those frameworks to create a program that is auditable and that you could produce to a regulator or a stakeholder or a vendor or a company buying your system to explain your approach to responsible AI. And important within that benchmarking are all of the laws that Janice and Rami highlighted, which is you've got to incorporate all of that legal compliance into a responsible AI governance program. I think one of the big issues right now within that program that are causing pain points for a lot of our clients that we're seeing daily is contracting. When you're buying AI from a vendor, there are major risks right now in the contracting space. So do you want to have an AI rider? Do you want to fight over the reps and warranties about accuracy and reliability? Who's going to shift responsibility if the AI goes wrong? Who owns the data, which is so important in the healthcare space, especially as it relates to HIPAA and the ability to use de-identified or anonymous data? How are you going to baseline who's being reasonable, getting back to that reasonableness and trustworthiness? Who's responsible for that? And I think in the contracting space, that becomes particularly difficult as vendors and enterprises are getting savvier on how to negotiate these AI contracts. And finally, I think AI literacy is a key component. And this is just culture. This is training. This is getting folks to understand the uses of AI, the benefits, the risks, to understand your strategic approach as an organization, and to understand where you're heading. And I think, Janice and Rami, and I'll turn it to you for your final thoughts. I think you take a page from cybersecurity and privacy. It's now cultural within healthcare organizations, cybersecurity and privacy. I think we increasingly are going to have to get there with AI. So I know we've got about 30 seconds left. If anyone has questions, they can populate it in the Q&A box and we can answer them offline. But Rami and Janice, any final thoughts before we kick things over to the insurance side with Natalie and Justine?
We're good.
I
Well,
think you've
terrific.
covered it, Peter.
Great. Well, thanks everybody for participating in our first hour of the CLE. It's now our pleasure to turn the program over to Natalie Limber, who is a partner in Denton's commercial litigation practice, and Justine Margulis, also in our insurance litigation practice, to dive into the world of AI and insurance. So over to you both.
Thank you, Peter, and good afternoon to everyone joining us for the second hour of our series on hot topics in cyber, data privacy, and AI relevant to the insurance industry. My name is Justine Margolis, and I'm a partner in our Denton's New York litigation and disputes practice, where I primarily focus on class actions and other complex litigation affecting insurance and financial services companies. I'm joined today by my partner, Natalie Limber, from our LA office. Natalie has extensive experience representing and counseling insurers on a wide variety of coverage, bad faith, and regulatory matters. Today's agenda, after that great presentation on AI and healthcare, is to drill down more on how AI development is impacting the insurance industry specifically. We're first going to walk through the current state of AI development and how AI tools are being used by insurers. And next, we're going to discuss the current regulatory and legislative developments around AI and the application of those legal frameworks to the insurance industry. We're then going to turn to the intersection of AI with other hot topics that are impacting insurers, namely cyber and data security risks, and then discuss current trends around AI insurance class action litigation and coverage claims related to the use of AI. And finally, we're going to talk about compliance considerations and practical tips for risk mitigation when implementing AI solutions. For the benefit of those that are just joining us and may have missed the prior presentation's discussion of AI terminology, let's just start with some basic terms, and then we can talk about how AI is specifically being used in the insurance context. The term AI gets thrown around all the time, but what does it mean? We can start with a basic concept that AI is generally referring to technology that uses systems or algorithms to imitate human intelligence. You can think of AI as really existing on a continuum or spectrum, and where a particular function falls on the spectrum will depend on its relative sophistication, which in turn depends on the quality and quantity of data being used to train the AI system that you're talking about. So on one end of the spectrum, you can think of the most basic type of chatbot. We've all interacted with those types of basic chatbots, which have a menu where you click on a menu option and the next prompt is based on whatever you selected. These types of programs can only answer predefined questions with predefined answers and struggle with any kind of nuance. On the other end of the spectrum, we have artificial general intelligence. This is really just theoretical at this point. It doesn't fully exist. This would be the type of AI that could perform any type of task that replicates human reasoning, including those that require empathy or creativity. What about the term narrow AI? When we talk about the type of AI that exists now, we're really mostly talking about what's considered narrow AI. This AI can analyze and summarize large data sets, recognize patterns, and make predictions about behavior or forecast outcomes. It can be very useful for problem solving or decision making. ChatGPT, which many of you I'm sure are familiar with, despite its impressive capabilities, is really still just narrow AI. You may also hear the terms or heard them in the prior presentation about generative AI or large language models. And generative AI really just means AI that creates new images or texts based on existing patterns or data. Again, ChatGPT is a type of generative AI. Large language models are also a type of generative AI. They are trained to summarize huge amounts of human written language. But those types of models are only as intelligent as they are trained to be. If they are trained on biased, inaccurate, or incomplete data, they're going to yield inaccurate results. For example, many of you might remember IBM's Watson, which was an early AI platform renowned for its ability to answer questions in natural language. More than a decade ago, Watson gained fame for trouncing human contestants on the game show Jeopardy! However, Watson famously got one Jeopardy! Question terribly wrong. In the category, quote, US cities, the clue was its largest airport is named for a World War II hero, its second largest for a World War II battle. The human competitors both answered correctly with the answer, Chicago. But IBM's supercomputer guessed Toronto. Watson was, of course, mocked relentlessly for this mistake, as we all know Toronto is not a US city. But more intriguing was why Watson got it wrong. And IBM reported that several things probably confused Watson. First, the category names on Jeopardy! Are tricky. We all know they can be puns or wordplay. The answers don't often exactly fit into the category. And in Watson's training phase, it learned that categories only weakly suggest the kind of answer that is expected. And therefore, the machine downgraded their significance. This can be thought of as a type of bias in the machine's reasoning. The way the clue was written also provided an advantage for the humans and a disadvantage for Watson. The phrase US city wasn't in the question. If it had been, Watson would have given US cities much more weight as it searched for an answer. Adding to the confusion for Watson, there are cities named Toronto in the US, and Toronto in Canada has an American League baseball team. It probably picked up some of those facts from the written materials it was trained on. And also the written materials it was trained on didn't have much evidence in the data about linking airports to World War II names. This is a real-world example of how bias and incomplete data or coding can yield inaccurate results. Another interesting observation is that it took IBM quite a while to figure out just why Watson missed. And as AI models get more complicated and there are more and more layers of abstraction between the user and the model, it can of course become more and more difficult to understand and explain what is going on underneath and why. This one example aside, Watson obviously handily beat its human competitors. It became synonymous with AI overnight. It was a new star that was expected to do great things. And in fact, the first goal for Watson was an incredibly high one: real-time cancer diagnosis, the types of healthcare diagnosis we were just discussing in the last presentation. But as I'm sure you all know, in the years that followed, Watson failed to revolutionize healthcare. The problems were numerous, too many gaps in data. Collaborations with healthcare centers were marred by switches to different electronic record systems and struggling to decipher notes and patient histories. It may not have transformed healthcare overnight, but Watson still exists in some of the automated, more basic tasks we are seeing today in accounting, payments, technology operations, etc. So we've come a long way since Watson's early days. And where are we now? I'm not going to spend significant time on these details, as they were largely discussed in the prior presentation. But suffice to say, where we are now in the state of AI development seems to change daily. The pace at which technological innovations are coming to market is quickening. We have on this slide, as you can see, some of the big players in AI development, which are probably familiar names that you'll recognize. And AI investment is driving more and more of the economy and the stock market. With this amount of competition, being first to market is critical. Moving slow can put a company developing AI tools or implementing AI solutions at a competitive disadvantage relative to peers. But the risk of deploying AI tech irresponsibly can also have significant ramifications. And balancing that risk to community versus the risk to shareholders and innovation is a challenge. Overregulation, of course, can stifle innovation and put US companies at a competitive disadvantage, but underregulation can yield harmful outcomes for end users as well. Striking that balance is a challenge that is, of course, still in flux. And later on in this presentation, Natalie will walk through the current patchwork of regulation of AI, specifically in the insurance space. But before that, let's first talk more specifically about the ways in which AI is impacting the insurance space. Unlike other industries, insurance companies face risk from the use of AI from two different broad angles. One is, of course, insurance companies' own use of these tools. But insurers also face exposure from another angle, which is related to insureds' use of AI. With respect to insurers' use of AI, we are seeing AI tools being deployed to automate underwriting processes and claims adjudications, in pricing decisions, and in fraud detection. Insurers are using these tools to detect patterns that humans might otherwise miss. For instance, an anomaly that might trigger a fraud investigation, or gathering available information and comparing it to detect possible fraud. Another example is telematics for auto insurance pricing. For many years, insurance companies have offered incentives to people who agree to have their driving practices monitored. In these instances, the driver agrees affirmatively to download an app or install a monitoring device that keeps track of their driving habits. But what if that tech was not added after the fact, but embedded in the car when it was manufactured? The New York Times published several recent articles about insurers obtaining information on drivers' practices from programs embedded in the car's computer systems when the car was made, and then using that information in rating decisions. This, of course, raises questions about whether this data collection was disclosed to the consumers and the sharing of this data with third-party insurance companies. Currently, there is at least one lawsuit pending in Florida District Court against an automaker and other third-party data companies about this issue. The lawsuit alleges these companies invaded plaintiffs' privacy and violated unfair and deceptive trade practices statutes by compiling driver information without plaintiffs' knowing consent. Stay tuned on the outcome of this lawsuit and whether further cases arise in this space. So we just talked about the insurer's use of AI tools. On the coverage side, for right now, we are currently seeing a wait and see approach with respect to drafting specific exclusions related to the use of AI. In fact, instead of exclusions for AI risks, we're seeing endorsements that potentially expand coverage for AI risks, notably in cyber. And at least one carrier has introduced an endorsement that applies to attacks made using AI technology. Another insurer has introduced a product geared toward companies investing or creating AI models. During the earlier presentation, our colleagues discussed a number of opportunities and risks for the implementation of AI in healthcare. I want to now focus a little bit on AI development in health insurance specifically. Unlike in other insurance industries where underwriting is still widely employed and AI may present opportunities for streamlining underwriting decisions, traditional underwriting no longer applies to health insurance carriers in the post-ACA world. Since carriers can no longer rate or deny coverage for pre-existing conditions, that looks a little bit different. So this guaranteed issue environment puts more focus, of course, on rate setting. And what we are hearing from clients right now is that the current state of AI is not sufficiently developed to be meaningfully used in pricing exercises. The AI tools are just not great at digesting the kind of structured data sets that are currently used by actuaries for developing pricing models. And we'll have to wait and see whether new models and tools remedy this issue. Like for other insurance lines, AI and algorithmic tools are being employed, however, to automate and expedite claims processing. And we'll talk a little bit later about the state of litigation related to those practices. Algorithms and machine learning can also be useful tools for capturing patient diagnoses for use in coding and reimbursements. And there's also a major potential for the use of AI in flagging patients for medical care and evaluating resource needs in communities. However, we've talked a little bit about the bias and issues that can happen when deploying AI tools, and great care needs to be taken in developing these tools for potential biases. For example, it would be logical for a model to use an insured's current healthcare usage and costs to estimate overall healthcare needs. In other words, using the patient's prior healthcare expenses as an indicator of future costs, and then in turn, their potential need for extra medical care. That makes sense theoretically, right? Taking care of a more ill patient will cost more than someone who isn't ill. And if a patient has higher healthcare usage and costs now relative to the average, that seems like it would be a good proxy for predicting higher future healthcare needs. But it's not always that simple. There are many reasons why this one comparison doesn't always work. For example, disparities in healthcare access, distrust of health providers, or out-of-pocket expenses are just a few reasons why someone may not use health services unless they're experiencing a more extreme level of illness or pain. This individual will have lower healthcare costs, even if their medical need is actually the same or higher as someone else's. Developers of this algorithm may have thought that by using an objective figure like overall healthcare costs, that their model would of course be objective. However, it's always important to recognize that data can still be a reflection of social and economic contexts that they come from, meaning that even a supposedly neutral number can reflect underlying biases. So when developing models, it's critical to look beyond the data and ask why we're using a certain tool or method to address a problem and how that model is actually generating a result. As I noted earlier, this becomes more and more challenging as AI tools become more abstract and complex. I'll now turn to Natalie to discuss some of the regulatory developments.
Thank you, Justine, and hello, everyone. As AI technology has advanced, regulators and legislators are working to keep up. Our colleagues discussed several or touched on several of these developments early on. In the US, as with many things, there is somewhat of a patchwork state-by-state approach to AI regulation in the insurance space, but we are seeing that smooth out. Justine and I are from New York and California, respectively. Our state's insurance regulators have come out with their own regulatory guidance directed at insurers' use of AI. Over 20 states, though, have adopted the NAIC's model rule. It is important to note that concerns from regulators in all states about big data and analytics are not new. Concerns from regulators about discrimination, privacy, and unfair claims practices are not new. In many cases, there are already regulations in place addressing things like discrimination, privacy, and unfair claims practices. Those regulations still apply even when AI is involved. What is new about AI regulation? We are seeing common principles come into focus that attempt to balance competing factors. Peter talked about the risk-based approach that is starting to emerge around transparency, accountability, fairness, usually in the form of non-discrimination, internal controls, privacy and data protection, a human-centered approach, but still looking to foster innovation. Programs that demonstrate validation, testing, continued retesting, evaluation of data suitability, and documentation, as well as executive leaders who can speak with authority to these points, will be viewed more favorably by regulators if or when issues arise. You heard from Rami and Peter also about trends in state laws, and we'll pick up a little bit where they left off. Peter kicked off the session today with the statutory definition of AI adopted by California last year. And that was part of a slate of laws passed by the California legislature in this space. Perhaps what was most notable at the time was what did not get signed into law, and that was SB 1047, which targeted very large AI models with extraordinary computing power and carried the potential for civil penalties. The laws that were signed focused on transparency, disclosures, and opt-out rights. Additionally, there were bills supported by entertainment industry unions around labor agreement requirements, intellectual property protections, and the use of a person's digital replica that have gone into effect. Again, we saw a balancing of competing risks, protecting against discrete risks without stifling technological innovation. In New York, there is proposed legislation that would take effect January 1, 2027, aimed at discrimination risks associated with AI making a, quote, consequential decision in several enumerated areas, including insurance. A consequential decision is any decision that has a material, legal, or similarly significant effect in terms of access, cost, or terms offered to a consumer. New York Assembly member Alex Boris, who has a background in computer science, is very active in this space and is looking to introduce a version of the California bill, SB 1047, that was vetoed by Governor Newsom in California. So we are keeping an eye on that. But New York, like California, has passed discrete laws addressing things like deep fakes and digital likeness. Picking up where Peter left off in Colorado, the Colorado AI Act also uses this consequential decision language, taking a risk-based approach and focusing on high-risk AI systems. And there are requirements on both developers and deployers around disclosure and documentation. The Act sets forth certain boxes a deployer, so that would be for an insurance company, the insurance company using an AI system developed by someone else, of a high-risk AI system that can check. There are several boxes that a deployer can check to show satisfaction of a reasonable care standard. The criteria includes having an up-to-date and proportional risk management policy and program. The Colorado Act refers to the NIST framework as a benchmark. There is also criteria for the periodic performance of impact assessments. Other states, including Indiana, specifically as respects health insurance, have taken a targeted approach focusing on disclosure and opt-out opportunities for consumers. As mentioned at the beginning of the webinar, we need to take a brief moment to satisfy CLE requirements by delivering the following code word. All Kansas, New York, New Jersey, and Pennsylvania licensed attendees must type the code word privacy into the Q&A section of your screen. Please make sure to hit the send button so that it registers. In case you missed it the first time, the code word is privacy. Touching briefly on the EU, which has historically been a much more highly regulated environment for tech companies compared to the US. The AI Act is another attempt at a risk-based approach. It has broad application to those involved in any aspect of the AI ecosystem with a link to the EU market. It classifies AI systems according to 4 risk levels: unacceptable, high, limited, or minimal. In the unacceptable risk category are those AI systems considered to pose a threat to people by way of cognitive behavioral manipulation, social scoring, biometric categorization, or facial recognition. The high risk category is relevant to the insurance industry as it includes pricing and risk assessment by life and health insurers. Limited and minimal risk AI systems must comply with transparency and disclosure requirements pertaining to the input used and indicated in connection with output. Cyber is another area that's seen a lot of recent regulatory activity. As you have already heard today, AI and cyber risks intersect in a number of ways that impact a company's risk profile. The good news, AI tools are helping businesses identify cyber risks. Unfortunately, bad actors are also using AI tools to scale their efforts, such as generating phishing emails, etc. It's important to remember that the large amounts of data needed to effectively train a large language model. And if that data isn't secure and there is a breach, exposure is potentially magnified. We have aggressively defended cybersecurity enforcement proceedings in New York, including challenging the department's claim that Part 50 allows for a penalty of $1,000 for each incident of NPI improperly disclosed. So what are we seeing in terms of commonalities between AI and cyber regulations? We see common emphasis on governance and risk management from the top down, an emphasis on training top to bottom, and disclosure of risks and incidents. Documentation can really be helpful. Cyber risks present a significant challenge to the industry given the volume and types of data that insurers have regarding consumers. As with AI, there is often a risk-based approach taken to cyber governance. And being able to demonstrate where choices were made and risks were assessed can be beneficial in explaining decisions to regulators. And that's true in whether talking about an AI program or a cyber program, but demonstrating where those potential trade-offs were made, why those decisions were made, what risk was addressed or prioritized can be helpful. As with cyber, there is also significant overlay between privacy and AI. Peter touched on this and we'll pick up where he left off. We have talked a lot about the output of a model and, for instance, whether that output leads to a discriminatory result or harms the consumer. Privacy risks with AI tend to have a lot to do with the data that is being input into a model or incorporated into a model. This means whether consumer or customer data is being used to train a model, whether PII is being put into a third-party application, which could be considered sharing with that third party. California regulators, as Peter mentioned, are requiring privacy policy updates about the use of automated decision-making technology, which is any technology that makes decisions or that a person relies upon to make a decision. The EU has been more active from a regulatory standpoint with respect to privacy than the US, and regulators have imposed big fines on tech companies for privacy violations. The fines mentioned on this slide are not specific to AI, but they are still illustrative. In July of last year, Uber was fined at 290 million euros for violating GDPR by transferring European drivers' data to the US without adequate safeguards. In 2023, Meta was fined 1.2 billion euros, also for GDPR violations related to Facebook's data transfers from the US, or from Europe to the US, excuse me. What makes AI interesting and challenging in this area is that it becomes much harder to disentangle data once it's been incorporated into AI development. So Justine is going to speak to that a little bit more in the context of HIPAA.
Thank you, Natalie. As the group mentioned in the prior presentation, HIPAA, of course, applies to protected health information, and health insurers are of course, covered entities to which HIPAA will also apply. We talked a little bit in the prior presentation about efforts that are made to keep PHI within a HIPAA compliant environment, whether that be by large entities developing AI models internally or smaller entities banding together in cooperatives to use that data in a HIPAA compliant environment. But the question was raised about when you use limited data, then do you potentially limit the usage of your AI or inadvertently yield inaccurate or biased results because you don't have a large enough data set? So I want to talk a little bit about concerns and issues and things that you should keep in mind in the event that you are collaborating with folks outside the HIPAA compliant environment and creating AI models. As Natalie mentioned, AI in particular is an area where it's really difficult. You cannot put the toothpaste back in the tube. If there are problems with the use of data or your model, you can't just slap a disclaimer on it and then move on. The data's out there, it's exposed, and probably huge amounts of money and time have been spent developing models that are not in compliance with law. So a couple of high-level things to keep in mind when considering using PHI to train an AI model. And one is authorization. Do the people accessing the data have the appropriate authority to use PHI in AI technology? And if using PHI for training purposes, you may first need to obtain an appropriate HIPAA authorization from each patient for whom that PHI applies. This, of course, will be very challenging, could be slow, and it can hinder the ability to use sufficient data to appropriately train the model. The second is security. Security measures must be in place to adequately protect the integrity, confidentiality, and availability of the PHI to prevent unauthorized access or use. Thoroughly assessing the adequacy of those security controls is particularly challenging and critical if the AI technology is pulling in and using data from multiple sources, and if the AI technology is being accessed by multiple parties. Another important limitation on the use of PHI under HIPAA is that only the minimum amount of PHI necessary for its intended purposes can be used. And as we've talked about, large amounts of data are typically required to train an AI model accurately. So how much PHI is enough? These are questions that will have to be answered. And who would decide how much is enough? And is the PHI being used for its intended purposes? Is someone going to oversee the use of PHI to ensure that it does not violate the HIPAA privacy rule? Later on in this presentation, we are going to discuss some risk mitigation tools and best practices for implementing AI responsibly. But as you can see, when it comes to PHI in particular, there are a number of other additional concerns beyond those that wouldn't apply to other types of data. We heard from our earlier panel about some current litigation risks of using AI. Let's focus now on the current trends in class action litigation facing insurers relative to their use of AI tools. Several putative class actions are currently pending against major U.S. insurance companies in connection with their use of AI for processing of prior authorizations and coverage claims. Each of these cases allege insurers have implemented algorithms that result in unfair, systematic denial of claims. For example, in estate of Gene B. Lock-in versus United Health Group, estates of patients who had post-acute care coverage terminated filed a putative class action complaint. They allege that the insurance company's reliance on AI tools to deny certain medical claims under Medicare Advantage plans constituted breach of contract, breach of the implied covenant of good faith and fair dealing, unjust enrichment, and bad faith. They claimed that the carrier's use of AI to make coverage decisions ignored clinical determinations made by providers, which prevented patients from being able to afford critical treatments and ultimately harmed patient health. The plaintiffs specifically alleged that defendants implemented these AI models despite knowing that they had a 90% error rate. And they further alleged that employee decision makers who deviate from the predictive model were disciplined or terminated. Defendants moved to dismiss. However, just last month, the District Court of Minnesota issued its opinion allowing certain of plaintiffs' state law claims, namely breach of contract and breach of implied covenant of fair dealing, to proceed. Other claims for unjust enrichment, bad faith, and state statutory claims were found to be preempted by the Medicare Advantage Act. With respect to bad faith, the court specifically found that any evaluation of reasonableness of the claim denial would require the court to evaluate standards under the Medicare Act, as opposed to standards, for instance, only in the insurer's written documents, and therefore found that this bad faith claim was preempted by the Medicare Act. There are similar class actions challenging the use of AI in connection with coverage decisions that have been brought against other insurers, both in relation to Medicare Advantage plans and in the commercial context, and alleging various violations of both ERISA and state law. For example, in California State Court, plaintiff Jeremy Jong filed a putative class action complaint against Blue Shield of California. Similar to the lock-in case, plaintiff alleged that Blue Shield used AI to systematically deny coverage en masse for treatments, medications, and testing that do not match a certain preset criteria, and that this AI software-driven process allowed the insurer to evade legally required individual physician review process. Implicit in plaintiff's claims was that the AI software was being used in a manner that did not include sufficient human oversight. They contended that doctors signed off on the denials. They contended that doctors signed off on the denials without individually reviewing the insured's files. Interestingly, when I dug into the procedural history of this case, I found that it had now been voluntarily dismissed with prejudice rather early on. Public files indicate that after the complaint was filed, counsel for defendant shared certain factual information regarding plaintiff's allegations that challenged the underlying basis of the claims. Precisely what factual information was shared and whether it was related to physician oversight of the claims is unknown. Nonetheless, the claims brought here raised numerous questions about the implementation of and effectiveness of using AI going forward to streamline claim review, depending on how much AI human oversight is going to be required. Subsequent to the filing of the Jong case, California's Physicians Make Decisions Act also went into effect, which precludes coverage denials from being solely based on AI algorithms. But of course, questions remain about how the standard of care will evolve over time. Right now, we are seeing an increased focus on making sure that there is human oversight. But over time, we may see an increased focus on the use of AI, and the failure to use AI may be considered problematic. In a different twist on AI litigation against health insurers, we are also seeing alleged violations of the Securities Exchange Act. At least one prominent insurer has been accused of making false or misleading statements about patient healthcare utilization trends, where the company's use of AI purportedly artificially suppressed utilization. Outside of the health insurance context, Husky versus State Farm, filed in the Northern District of Illinois, is also one to watch. Here, plaintiffs filed a putative class action lawsuit under the Fair Housing Act. The lawsuit alleges that the insurer dealt with homeowners' insurance claims in a racially discriminatory manner and sought a declaratory judgment, injunctive relief, damages, and attorney's fees. Plaintiff contends that the program used to predict if claims might be fraudulent was biased against Black homeowners, causing them to have to go through more hurdles when they submitted claims than white homeowners. They allege that even when the models do not input data about race, the algorithms can learn to combine other inputs correlated with race to produce discriminatory effects, and that this creates a vicious cycle. A biased algorithm imposes greater scrutiny on Black claimants will find more fraud among Black claimants, leading to even higher scrutiny. In other words, the plaintiffs allege that more fraud investigation will inevitably lead to finding more fraud, creating a feedback loop in which Black claimants are more heavily scrutinized. On a motion to dismiss, the court parsed the language of the Fair Housing Act, upholding in part and dismissing in part the claims. Of particular note, the court held that plaintiff had adequately alleged a disparate impact claim under the FHA by plausibly alleging a connection between the company's algorithm and the statistical racial disparities. The court found that plaintiff's allegations describing how machine learning algorithms are prone to bias, that this inference that the algorithmic tools had resulted in longer wait times and greater scrutiny for Black policyholders stated a plausible claim for relief. The court, however, dismissed claims for prospective injunctive relief, finding that since plaintiff was no longer a state farm policyholder, they faced no apparent threat of future injury and thus had no standing to pursue prospective injunctive relief. At the motion to dismiss stage, the court rejected defendants' arguments that the claims were barred by the McCarran-Ferguson Act. As some of you may be familiar with, the McCarran-Ferguson Act provides that no act of Congress, which in this case would be the Fair Housing Act, shall be construed to invalidate, impair, or supersede any law enacted by any state for the purpose of regulating the business of insurance, unless that particular act also specifically relates to the business of insurance. Since the Fair Housing Act does not specifically relate to the business of insurance, the question was whether its application here would invalidate, impair, or supersede any Illinois insurance law. The court found that on the current record, there was no showing of a direct conflict and rejected this argument. However, the court did leave the door open to raising this argument again, stating if that through discovery, it became clear that liability under the Fair Housing Act depends on actuarial soundness of claims handling practices in a way that it interferes with state insurance policy or administrative regimes, McCarran-Ferguson may apply to preempt the claims. So let's talk about some key takeaways from these cases we just discussed. Of note, each of these cases was brought by a different plaintiff's firm, which is perhaps an early indication of a cottage industry developing and that we may see more claims being filed in this space. AI platforms are often described as being systematic processes, which of course makes them prime targets for plaintiffs' lawyers thinking about new angles for class litigation. The phrase systematic practice or policy is a ubiquitous one in class action complaints to try to establish commonality and that individualized issues don't predominate. None of these cases that we've discussed is yet at the class certification stage, but depending on the claim at issue, a policyholder may still need to show that the claim was wrongly denied, which would likely require individualized assessment. The implementation of human checkpoints along the way is another important step toward mitigating the risk of class treatment, and robust disclosures to consumers may also help in certain cases. One other thing that also stood out to me in these cases is that plaintiffs are pointing to express contract language in their policies. For instance, policy language that may state that determinations of medical necessity are made by a, quote, medical director. In other words, plaintiffs are claiming not an algorithm. You can imagine similar allegations about policies that say your claim will be inspected by the company, which may be defined as the issuing insurer. It remains to be seen what happens in these cases, but they highlight the need to take a look at longstanding policy language with fresh eyes when implementing AI systems. In at least one of these cases, defendants have made standing challenges. We talked about the standing challenge with respect to the prospective injunctive relief, but there have been also different types of standing arguments raised. Plaintiffs contend here that their claims were automatically rejected by an automated system, but in some cases, defendants have asserted that records for these claims show that they were not, in fact, denied through the automated review process, and that therefore plaintiffs lack standing to bring these claims. Framing this as a standing question is a interesting early tactic to try to get the matter dismissed early on, as opposed to waiting down the road to frame these as individualized questions, et cetera. This argument also brought to mind for me that California state case we were previously discussing, which was dismissed early on after plaintiff was provided with documents undermining its claims. Unknown whether those records would relate to any kind of standing argument, but this does raise some potential for interesting litigation strategies early on, and considering whether there's possibility for an early information exchange to show plaintiff that their claims are not viable if, in fact, there was not solely automated review. And to also consider whether sanctions motions are warranted if a plaintiff doesn't agree to dismiss when presented with evidence contradicting their claims. One other topic I think is important to remember here is the prospect of social inflation when we're talking about emotionally charged allegations about things like denial of healthcare to sick patients. Social inflation is the trend of juries being increasingly mad at big corporations and rendering nuclear jury verdicts, including large punitive damages awards. Insurers have always been uniquely exposed to social inflation, but allegations that a company misused AI tech or misused sensitive consumer data add another layer of potential risk. We regularly help clients develop trial strategies that mitigate the risk of nuclear verdicts. And developing a compelling theme and humanizing the company and its professionals, starting from the first filing all the way through trial submissions and verdicts, is essential. Humanizing, of course, becomes more challenging when you're talking about AI technology. So ensuring you have those human checkpoints, that you have clear documentation and practices, and that you have people and witnesses who can explain how the technology works and renders decisions will be critical.
So we wanted to spend a few minutes today talking about the potential coverage implications of AI risks. We've talked about insurer adoption of AI, but earlier Justine talked about the market response insurers have taken or not taken with regard to AI-related risks. She also discussed what those risks are. For the most part, they are risks that the insurance market already addresses, albeit with some nuances. So there is not a specific category of AI claims or AI coverage. What is important is to look at what is the underlying claim that is being alleged and what is the product or policy that addresses appropriately that claim. And then what are the terms of that policy that may or may not apply based on the unique facts at issue. So we're starting with E&O coverage because that we've talked a lot about professional standards of care today. And so, this is the category of coverage that includes coverage for healthcare providers, errors and omissions, architects and engineers, lawyers, other professionals. And so one of the nuances in coverage that may start to emerge has to do with that E&O coverage for professional services. A professional service is one that involves specialized knowledge, labor, or skill, and is predominantly mental or intellectual, as opposed to physical or manual in nature. And that comes from a particular case, the state bank case in Illinois, but there are cases from around the country that use similar type language in terms of defining what is a professional service, dating back to the early 2000s or the 1990s. A lot of times a professional service is marked by the need to have a license or certification. In this professional liability space, if ChatGPT can write code, interpret X-rays, or write a legal brief now or in the future, the role of the professional may begin to look different. It is possible that the democratization of these tools has an impact on what it means to exercise professional judgment. These policies cover liability, or typically cover liability arising out of the rendering or failure to render a professional service. So if in the rendering of a professional service, the professional misuses or over relies on AI, there may be arguments there as to whether or not that falls within that coverage grant. Janice mentioned earlier that we may see AI impact or shift the standard of care in healthcare, and that may be true in other professional settings as well. So as the technology evolves and improves, insurers evaluating claims against professionals or in the professional liability space should consider whether the failure to use available AI tools that exist is a failure to render a professional service or deviates from a professional standard of care. In the CGL space, commercial general liability, a number of AI-related risks have the potential to implicate coverage B, which is the personal and advertising injury coverage. In the traditional CGL policy, coverage B protects against a number of claims involving business activities or advertising that allegedly harm a person's reputation or rights. When it comes to AI, this could mean AI-generated images that are defamatory. We talked about deep fakes and the legislative activity addressing the risks of deep fakes. Violating a person's privacy rights by disclosing their personal information without consent. Using someone's copyrighted material to train a model without their permission. Using someone else's advertising ideas. If you have, trained a model, or if an insured has trained a model using the advertising ideas of others, and that output then potentially leverages those advertising ideas wrongfully, that could be a potential coverage B risk. In other words, there may be an AI component to what is otherwise an enumerated coverage B risk under standard CGL policy language. Directors and officers risks. This coverage is often implicated with respect to claims of misrepresentation by directors or officers of a company, including claims against the company itself. Right now, a lot of companies want to tout their AI capabilities, and Peter touched on this a little bit earlier. If those claims to the public or to investors overstate those capabilities, the insured may look to its D&O carrier under existing entity coverage forms. On the other hand, we have talked a lot today about the regulatory emphasis on disclosure by AI developers and deployers. If there is a lack of such disclosures regarding the nature and extent of an organization's AI use, as well as associated risk to the board or shareholders, just such a lack of transparency can lead to shareholder derivative suits and similar traditional D&O claims. Media policies, this is another space ripe for AI exposure. There is already at least one high-profile lawsuit by a publisher against an AI developer and investor for intellectual property violations for using content to train AI models without permission. Other coverages that may be implicated, we've talked a lot about cyber risks associated with AI, including the potential for increased scale of those risks, which clearly have the potential to trigger cyber coverage, including business interruption. As Justine mentioned earlier, it can be hard to, or impossible, to put the toothpaste back in the tube when you're talking about AI and what is in models. And if there is a breach that exposes customer or consumer data that is baked into the model, clearly there's the potential for a business interruption there. Employers' EPLI, employment practices liability. There's been a lot of discussion about the risk of discrimination from algorithmic screening and other AI implementations in hiring. Those have obvious EPLI implications, and not just insurer and healthcare HR departments, but insured HR practices certainly are something to be keeping an eye on when it comes to AI and the potential for EPLI exposures. A final note on coverage, these various policies may have intentional acts or violations of laws exclusions. So keeping up with that, the state of legislation we've touched on here, may be important for carriers evaluating claims relating to AI, especially given the speed with which that those legal developments are happening. And you know, when we're talking about coverage evaluations, and Justine talked about this in terms of class actions and the discussion of the litigation landscape, but there, when you have, regardless of what type of policy is being evaluated, when you have an AI involved in making coverage determinations or, you know, evaluating coverage, valuing a claim, whenever that has the potential for an adverse effect, there is the potential for bad faith. And so again, you know, still having humans involved to review claims decisions, regardless of what coverage or type of coverage is being evaluated, remains important. So compliance considerations, you know, both starting with the first panel and carrying through the insurance panel, we've seen an emphasis on the ownership of AI processes, procedures, and governance, the need for compliance with existing regulatory schemes. We've talked about the various cyber regulations in New York and at the federal level. We've talked about CCPA, in addition to the AI-specific regulations that are emerging. And so if companies don't have strong compliance with in the privacy and cyberspace, it may be advisable to take a walk, then run approach. So before deploying or developing AI tools, having robust compliance when it comes to privacy and cyber first may be something to consider. There's also privilege considerations in terms of developing compliance and, you know, getting lawyers and compliance involved from the outset in developing these tools and developing the programs and governance, because again, as we've said, it's very difficult to unring the bell when it comes to building and baking in data into these models. But using those privilege protections wisely by doing evaluations and engaging in-house and outside counsel. Key takeaways, again, transparency and disclosure, top to bottom approach to regulatory compliance, that smart governance that Peter and his team talked about, hands-on and empowered executive leaders who can articulate the governing principles around AI development and deployment, both to regulators and potentially in litigation. What were the risks that were assessed? What were the trade-offs? What were the choices that were made? And having that ownership is really key. Considering best practices as mandatory, some of the legislation, we touched on the Colorado legislation that is actually incorporating the NIST framework by name. So taking some of those best practices and really internalizing them can be helpful. And then, you know, appropriately communicating to investors, board members, consumers, regulators about AI capabilities, adoption and risk, implementing those opt-out processes, that's key. And, you know, AI, as we've discussed, can touch all aspects of an organization. So not having anything siloed, having that collaboration, having that consistent adoption of best practices is is really key. So with about 30 seconds left, I will close this out and say thank you again for participating in today's CLE webinar. In approximately 30 business days, you will receive an email with a link to your CLE certificate. Your webinar login details will be used to process these certificates. No additional steps are required. As a reminder, the code word requirement is only if you are seeking credit in Kansas, New York, New Jersey, or Pennsylvania. On behalf of Justine and myself and the healthcare group, thank you very much and have a great day.